we're going to be beginning in probably about 7 minutes. Thank you. Everybody, my name is Judge Kim Teresa Malika. You're here today in First Appearance Magistrate Court. Today we're going to determine if there's probable cause and determine bond amounts, if any. Today is not your trial day. Do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. Anything you say or do can and will be used against you. You also have the right to an attorney. We have a public defender, Mr. Romero, at the main jail, and we have Mr. Reedy here, who's in the courtroom with me. If you have a private attorney, when you step up to the podium, let me know. We're going to take a couple cases at a turn. We're going to take Jordan Salter. Are you,
Come on up now. Judge Ms. Salter is here, present at main.
okay. She's the first female. Okay. Okay, good morning. How are you? Okay, are you Jordan Salter?
Yes.
Okay, Ms. Salter, you're charged with count 1, possession of weapon on school property. We have to talk about setting bond, and then we have count 2, exhibit a destructive device weapon on school property. Who do we have here today? Okay, can you state your name for the record and then spell your last name?
Salter, S-A-L-T-E-R.
Okay.
Scott Salter, S-A-L-T-E-R.
Okay. All right, state?
Eric Linder on behalf of the state, Your Honor. Your Honor, the state is very concerned based on the allegations presented in the report. The state is going to be requesting bonds in the amount of $10,000 per count, pretrial release with a GPS monitor level 2, no return to the campus, in this case, in any school in Broward County, no possession of any firearms, weapons, or ammunition.
Hold on, you're going too fast. No return to school in Broward County. Go ahead.
No possession of firearms, weapons, or ammunition. And we'd also be requesting, pursuant to Florida statute, that the court orders a psychological evaluation.
Okay.
Your Honor, she's charged with pouring some coffee onto a guy who made an extremely rude comment to her and probably had it coming. I don't know when we all hit the fear button where everything is just an absolute emergency. What the state's asking is ridiculous. This guy asks her, and you can see in the probable cause affidavit what he asked her, and she poured coffee on him. And I'm not so sure that I wouldn't have done the same thing if he had said that to me. And then when he threatens her and gets in her face, then, according to the affidavit, she reaches inside of her clothing and pulls out a 2-inch black-handled knife to keep him away from her. That's the only reason she produced this weapon. I don't blame a kid for taking a weapon to school, quite frankly, these days. And a 2-inch black-handled knife? And the state wants a $10,000 bond and a psychological evaluation? I think maybe we should have this kid who asked her these questions, maybe he's the one who needs a psychological evaluation.
Well, we're not here for that today.
Well, we are here for this today. And we were here for this yesterday, and it seems like we're here for this every day. And this is an absolute ridiculous accusation against her. I'm going to ask you to release her to her parents' custody. She doesn't need a psychological evaluation. She doesn't need a $10,000 bond. This kid makes a rude comment to her, and she pours coffee on him, and when he gets in her face, she moves to protect herself, and that is clearly what is in front of this court right now.
But she had a 2-inch black knife at school.
Yeah, I don't blame her with people like this guy asking her these kinds of questions and getting in her face.
Okay, I asked him a question, just
No,
wait.
I was just going to ask if I could briefly respond.
I will let you.
Thank you.
Okay, go ahead, Mr.
Your Honor, first, if we're going to go into the allegations, I think we should be accurate on the record. Because the comments were not made to Ms. Salter. And we're not here because of the comments he made. We're here because Ms. Salter brought a knife onto this school's property. That is why we are here.
Well, it says Judge Rick asked Kat.
That's not that's her friend.
I understand.
Okay, but I just want to, I think if we're gonna go into the facts, we should be as accurate, we should be accurate.
Because it says Kat poured her iced coffee onto Jedrick.
Yes, I'm just saying that Ms. Aridi is making statements that this individual threatened to assault her. There's nothing in the report to indicate that.
So they're fine.
Excuse me,
They're
excuse me,
together.
Excuse me.
Let him finish.
There's nothing here to indicate that he threatened anybody.
Yes, there is. It says right here, he got
Mr. Reedy.
closer into her face.
Mr. Reedy, this is not how it works. He let you talk. Let him talk, please. Please.
Yes, ma'am.
Go ahead, Mr. Linder.
There's nothing here to indicate that he threatened anybody, but that's really besides the point. We're here for one reason, and one reason only, because she brought a knife here onto this onto this campus. And Mr. Reedy's suggesting, why all the fear? Well, there should be fear. 17 people were killed on this campus a month ago. So yeah, there should absolutely be a concern with anyone bringing a weapon onto this or any other school campus.
Yes, and we have a kid sitting in jail on a $500,000 bond on a misdemeanor because he was armed with a skateboard. This is just, Judge, this is just out of control to ask for a $10,000 bond. Yes, there's a reasonable way to do this.
Mr. Linder was not finished.
Oh, I thought he was.
I was, but I would object. I don't understand how that case is relevant to this case.
You brought it up.
Okay. Do you have anything further to say, Mr.
Yes, Your Honor, I think there's a reasonable way to do this. She has to stay away from that campus. I agree with that. And I think her parents would agree with that as well. And she can stay with her parents where she lives. I don't know if she's ever been in trouble before.
I'm going to give you an opportunity to respond, okay?
But I would say ROR, no contact with anyone at this school, not to return to that campus, not to be in possession of any weapons. If you want to put her on pretrial release so that she has to report to them as well, that's fine. She's 18 years old. I take it she's still in school. She hasn't graduated yet. She may have to change schools or go somewhere else or even go to school online. But a $10,000 bond, a psychological evaluation, and all of these things, Judge, is just way beyond the pale of what this probable cause affidavit calls for.
Okay. I heard you. Anything further that you haven't told me?
Yeah, there is, but I'm done.
Okay. All right. Can you swear the parents in, Madam Clerk? Sir.
Scott Salter, Salter.
Okay. What would you like to tell the court today?
I was just saying, my daughter's never been in trouble a day in her life. She was threatened by this guy. Her and her friend both were accosted by the guy previous to this. And, you know, under the circumstances, I understand she should have never had a weapon, but
She was terrified.
She's terrified.
I had to practically shove her in the car to get her to go back to that school.
So, I mean, I agree. I don't think this is the first time she's ever been in any kind of trouble. She's never exhibited any kind of behavior like this.
Will you make sure that she comes back to court if, in the event that these charges are ever filed?
Absolutely.
And this kid had been stalking them for like 2 days.
Okay. So is there anything else you'd like to tell the court?
We will do whatever you say. We'll follow the law.
All right, the court does find probable cause. The court is going to return. I'm just going to do no return to this school at 11,000 Hamburg Road, Parkland, Florida. I'm not going to say whether she should go to an internet school or something like that. She's to possess no firearms, ammunitions, or weapons. And if she does have any, immediately upon her release, she's to surrender them to her local police department. I am going to put a GPS monitor on her open schedule. That's without prejudice for her to go to our division judge and have them file a motion. Court's gonna do a $5,000 bond on count one. Court's gonna do a $10,000 bond on count two. Not gonna order a psychological evaluation. Thank you. Good luck to you.
Just for clarification, and I apologize if I missed it, the court ordered no return to this particular campus.
Correct.
Did you order no return?
No, just to this particular campus.
Okay.
Okay?
All right, that's over a state's objection.
I understand.
She wants $1,500, right?
Yeah, you realize, Judge, the victim doesn't want to prosecute this case, only the state.
This is not a victim case. That's why
Okay,
she's
I
in
made
charge of
my
assault.
ruling. We're moving on. Thank you.
Can you make that bond, Mr. and Mrs. Salter? Do you want to see her sit in jail, Judge?
Objection, Your Honor.
Judge,
Hold on, I'm reading something. Just hold on.
yes, Your Honor.
All right, let's talk about bond.
Judge, if I may, I haven't had an opportunity to address the court. Judge,
All right,
in
go
speaking
ahead,
with Mrs.
Mr.
Salter,
Romero.
thank you, Your Honor. In speaking with Ms. Salter, as you heard, this is her first contact with the criminal justice system. She is going to school. Her goal in life is basically to be a dental hygienist. Obviously, right now, there's more pressing issues, and at this time, we wouldn't object as far as no return to school, and I'm glad Your Honor did not impose the request that the state asking for as far as no return to any school. I believe there's an internal mechanism, the school board, to see that this case is handled accordingly. Having said that, Judge, her parents don't own their home. They actually rent their apartment. So they're not homeowners. They live in a two-bedroom, two-bath apartment. She happens to share her bedroom with her other brother. Judge, from what she told me, financial resources are limited. They are not unlimited. The $15,000 bond, which Your Honor has imposed, I believe at this point is out of their reach, Judge. I'd ask you at this time to take testimony from her parents to see how much they can afford, Judge. And based on that, obviously Ms. Salter is not working. She has no savings. She has no money in the bank. She has no money in property or anything like that. So from her position, she's going to be relying strictly on her parents, Judge. So I'd ask you at this time to take into consideration what her parents' financials, resources are, and impose a more reasonable bond on Ms. Salter's behalf.
Judge, I'd ask you for a $2,500
All right, we're
bond
not
on each count.
We're not double teaming. He can do the rest of the work with regard to the bond.
From what I understand from speaking with Mr. and Mrs. Salter, they can afford a $2,500 bond on each count, which I think is more than reasonable.
Mr. Linder?
Your Honor, I think the bonds that the court set were reasonable considering the totality of the circumstances.
Considering the totality of the circumstances, she shouldn't have even been arrested considering the
We're not going
totality
back
of the
and forth.
circumstances.
Okay. Let's inquire into their finances, Mr. Reedy.
Would you like to do that, or would you like me to do that?
I would like you to do it.
How much money can you afford for bond, folks?
Short of $500.
And do you have any collateral that you could use to?
Yeah, we don't have anything.
Do you have a bank account?
Savings, we have nothing. We moved here and took everything we had to put her in a safe school.
How's that working
We
out?
live in Parkland in an apartment
All right, we
just
don't
to
need
be
to
able
go
to do
there,
this.
Mr. Reedy.
I know.
What do you do for a living?
I do sales and project management
And I
for
work in-
security.
I work in an online retail service. We sell hats.
What are your annual salaries?
I make $16 an hour.
It's an hour.
Judge, she's not going to be going anywhere. She's got no criminal history. She was accosted by this person.
You know what? I don't need to hear about, it's just about the money at this point. I
Well, there
heard your
isn't
argument.
much.
I understand what your argument is. I heard it. State?
And let the court keep the bonds that you had said, 5,000, 10,000 in place.
And you're locking her up.
Mr. Reedy?
It's true.
Mr. Reedy, please.
I'd ask you to ROR her, Judge. Where's she going?
She lived at the address with you, the apartment. How long have you all lived there? All right, this is what the court's gonna do. The court's gonna keep the bond at 5,000 on count 1, and count 2, the court will make it 7,500. The court does have a concern that this child brought a knife to school. Thank you. Good luck.
$750.
12-5.
So it's 12. Thank you.
You're welcome.
Don't go anywhere.
Jacqueline Garcia, please. Pardon?
Oh, Judge, right now I believe Mr. McLawrence is speaking to her. She's at North Broward.
Oh, it's an
Wanted
MO
on-
case. All right, I'll put it.
Judge,
I'll
if we
it
can put it on recall, Mr. McLawrence is speaking to her right now.
on. Okay, thank
Go
you.
ahead, go ahead. Did you hang it
Erica
up?
Sherry Tillman, please. I didn't even realize it was an MO and I had it flagged as that. Okay.
Erica Tillman is at North Broward, Judge.
Okay,
She's
thank
a medical
you.
research order. Judge Monica,
Yes, sir.
good morning.
Hi.
Will you please take one out of turn, please?
Sure.
Bada Lola on page 3.
Judge, we're going to have to recall that. I'm waiting for someone from our juvenile system to come down here. They should be on their way. I'm sorry, Deputy.
That's okay.
Well, let's hope so.
It's on recall. Let me know when they get here. Okay, I think the next one is Shatara Higgins.
Judge, Ms. Higgins is here present at Maine.
Thank you, Mr. Romero. All right, good morning, Ms. Higgins. You have count 1, operating without a valid DL. Count 2, failure to register a motor vehicle. Count 3, attach a registration license plate not assigned. Count 4 and 5 are 2 capiases for misdemeanors. It looks like it's going to be set in division. It looks like MS, my old division, $500 bonds each. No, it's division MD, it says. Okay. No-show arraignment for operating without a valid license, 500. Failure to register a vehicle, 500.
Judge, and
Hold on one moment. Mr. Reedy,
yeah.
any objection to probable cause on Ms. Higgins, please?
No, Your Honor.
Okay, the court does find probable cause. So we have a total bond of $1,025, Mr. Romero.
Judge, respectfully, Higgins, in discussing this matter, she's interested in asking Your Honor if the court would be inclined to offer an adjudication time served on all counts. Judge, she is going to school here. She is right now. She's a single mom trying to support her kids. She wants to go ahead and put this behind her and wants to go forward in her life. So, Judge, at this time, we'd be asking you to consider an adjudication time served on Ms. Higgins' behalf.
Okay, state, any objection?
No, Your Honor.
Okay. All right, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, is your name Shatara Marlena Higgins, Higgins, ma'am?
Yes.
Okay, you can put your hand down. It's my understanding you wish to waive your right to a trial?
I can hear her.
To waive your right to a trial?
Yes.
Is anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
Understanding what I just explained to you, you're pleading guilty, no contest, or not guilty to count 1, operating without a valid DL, failure to register a motor vehicle, attach a registration license plate not assigned, and counts 4 and 5 are operating without a valid license and failure to register a vehicle again.
How are you pleading?
No contest.
Okay, thank you, Mr. Romero. The court is going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court is going to adjudicate you and time serve you on each count. The court is going to impose $293 in court costs, 2 times, I believe. These are 2 separate cases, correct? Yes. Okay. All right. So the court's going to impose $293 in the one case and $293 in the second case. How much
Judge
time
and
to
Mr.
pay?
Higgins will be requesting 1 year time to pay.
Okay, 1 year to pay on 1 year to pay court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, ma'am. You're done with this case except for paying your court costs. Good luck to you.
Good luck, ma'am. There you'll be processed and released today. Okay?
Mr. Romero, when you plead them out, if you want to plead them out, just let me know if they have any felonies pending or anything else.
If I can, but Judge,
No, I
as
know.
you know, I don't have access to a computer.
No,
so.
I know, but maybe you can ask them if they have any other pending cases. Because I just want to make sure that, you know, with the felonies, we don't plea them out. All right, so Alyssa McNearney.
She's in North Broward, Your Honor, and she'd like to resolve these matters if possible today.
Okay, do you know if she has any pending felonies?
I don't believe that she does, Judge.
Okay. Yes.
Excellent.
Okay, Lola Battle, the bond's being posted, so can we just hold on one moment? Let's just call it and just, oh, all right, Lola Battle, she's gotta know not to be no return to TJ Maxx. Hold on, let's go, we're gonna go off the record one moment. Broward.
Yes, ma'am.
Okay. The juvenile is going to be transferred to the Juvenile Assessment Center. Okay?
Okay,
All right, just so you know. Thank you.
thank you.
Okay.
Ordered that BSO shall return the bond in this case and shall transport the juvenile to the Juvenile Assessment Center.
Okay, here you go, Madam Clerk. All right, Elisa McNearney. Medical loan, right?
No,
Medical?
she's back.
Oh, she is? Okay.
Live from here on out, right? You're welcome, you're welcome. Anytime.
Hey,
Your
Myers,
Honor.
we'll take your case right after this, okay? All right. How do you say
Miss
your last name, ma'am?
McInerney, I would guess, a fine Irish name.
Okay,
Judge, Miss McInerney would like to resolve these matters if possible this morning.
okay. All right, ma'am, you have false ID given to Leo, possession of cannabis, drug paraphernalia, and trespass. Property, not a structure or conveyance.
Judge, I'd be asking for a withheld adjudication in court costs. Thanks again, Jen. Okay, okay, bye-bye.
Thank you. Okay, State.
Name Vic Simon on behalf of the state, just for the record. State would be offering a withhold in court costs to resolve these cases today due to the fact that she is out of. Withhold court costs, yeah.
Okay, and no return to the residence in Marriott.
Yes, Your
Mr.
Honor.
Reedy?
Yes, Miss McInerney, you can't go back to that location. You understand that?
Yes.
The Residence Inn at 3333 Northeast 33rd Avenue.
Oh, Mr. Lawrence.
It's a lot of threes.
A lot of cases. Okay. All right. Ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, state your first and last name and spell your last name for the record. Put your hand down.
Alyssa McInerney, McInerney.
Okay, ma'am, it's my understanding you wish to waive your right to a trial.
Yes.
Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication that would affect your ability to understand what's going on here today?
No.
Ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
Do you agree not to return to the residence in Marriott where this alleged incident occurred,
Yes.
which is at 3333 Northeast 33rd Ave?
Yes.
Okay, you want to plead no contest to false ID given to Leo, possession of cannabis, 20 grams or less, drug paraphernalia, trespass, property, not structure or conveyance?
Yes.
Okay, the court's going to accept your plea, find that it's freely and voluntarily given. The court is going to withhold adjudication on each count, impose court costs on count one only, which is $293. Time to pay, Mr. Reedy?
How long will it take you to pay that, Miss McInerney? Can you pay it within 6 months?
You can get up
Yes.
to 1 year, ma'am.
Okay.
So how much time do you need? 1 year?
6 months is.
Okay, 6 months.
Okay. Okay, the court will give you 6 months to pay the $293. The court will take judicial notice of the time that you served in the Broward County Jail. Good luck to you, ma'am. You're done with this case except for paying the $293, okay?
Okay.
All right, Mr. McLawrence will get you after Ms. Myers. Okay, is it William?
Yeah.
Willian?
Yes.
Okay. William C. Cardoza D. Oliveri. Do we know where he is?
He's here present at Maine.
Okay, we have a private attorney.
Public defender. Oh, we have private defender.
Okay, are you Mr. Cardoza D. Oliveri, sir?
Yes.
Okay, you waive formal reading?
Yes, Your Honor.
Okay.
Good
Any
morning.
Good morning.
For record purposes, Leah Mayerson on behalf of William Cardozo de Oliveira. I was retained by his husband this morning, Your Honor.
Okay.
Your Honor, I understand that he has no priors. He is not a flight risk. His husband has retained me. They live in Broward County. He has a full-time job at Sushi Gama. His husband works for Citrix. The probable cause affidavit appears to be a little deceptive. His first language is Portuguese, and in speaking with his husband indicated that
Does he speak English?
he speaks English. Yes, I think he's just very upset. And the husband said he has a condition that when he gets very nervous, it's very hard for him to articulate what's going on, which is why he might not have been properly able to explain everything to law enforcement, and I think they misinterpreted it. Husband said their entire relationship, photographs have only been of him for the husband, private photographs. There have never been any photographs of any third-party individuals, and that he never intended to do that. We would ask that he be released on his own recognizance. In the alternative, we would request a low bond so that his husband can afford to post it. Like I said, the husband explained he's an upstanding member of the community, and I think this was misinterpreted due to his sexual orientation of what he was doing to himself. And William, just take a deep breath. You'll come to my office later today, okay? Take a deep breath.
All right, Mr. Linder.
Your Honor, I'm going to be requesting a $15,000 bond. Obviously, no victim contact. I'm also going to be requesting, until further order of the court, Mr. Cardozo de Oliveira not being in possession of any recording devices, Your Honor. Just noting, and I understand Ms. Mayerson's explained to the court that his husband says he gets nervous and but, Your Honor, these different versions he gave are completely different from one another. It's not just a matter of, a misinterpretation. He told law enforcement that the victim kicked in the stall door. The officer investigated. That stall door was not kicked in. After he gave the second version that he was taking a picture of himself, he looked at the phone. The picture was not being taken of himself. It was being taken towards the direction of the wall of the stall. So I am concerned, based on these allegations, it would appear, based on the totality of the allegations, that there's certainly reason to believe he was trying to do what he's accused of doing. I won't go into the details, Your Honor.
It's okay.
Your Honor, I don't think that the stories are inconsistent. Just because there wasn't physical damage. I mean, if you've been to Sawgrass, the bathrooms are set like, they're for an army barricade. So just because someone kicks in the door doesn't mean it's going to permanently damage it when you have these heavy-duty doors there. And his version of the events was that he, when the guy kicked in the door, he, I guess, slipped. And there's nothing to indicate that the camera was underneath or anywhere else or indicating anything else. He actually voluntarily unlocked his phone and handed it to law enforcement. And the only photographs, according to the husband, were of himself. And I guess the husband sent some photos as well. So in looking at everything, there was nothing to indicate there were any photographs of the alleged victim in this particular case. He had also indicated that the victim in this particular case was high on drugs. Unfortunately, all the cell phones now have cameras on them. If you restrict them from having any kind of a recording device, he's not going to be able to have a phone, which is a safety issue for him. I would request that you don't place any restrictions on him. Again, like I said, he's never been in trouble before. He's got substantial ties to the community. He lives here. He works here. Stable home environment, no priors.
There are still phones that can be purchased that do not have video recording devices on them, one. Two, Your Honor, and I'm just reading directly from the report, the officer, who's the only one out of everyone here that actually looked at the phone, specifically states, the photo appeared to be at the defendant's feet and pointing towards the stall wall.
And, Your Honor, that would be consistent if someone knocked into you and you're holding your phone. I mean, I can't tell you how many times I've accidentally taken photos of my feet or the wrong thing. It certainly isn't indicative of anything, and certainly not indicative of guilt.
All right, the court's going to find probable cause. The court's going to order no victim contact, sir, direct or indirect. That means in person, calling, texting, or anything like that. Any contact through social media or third parties. The alleged victim's initials are KMM. Also, you're not to possess any recording devices. The court is going to set a $7,500 bond. However, the court is going to do a GPS open schedule. Thank you.
Thank you, Your Honor.
Good luck to you. Thank you. All right. Thank you, sir. Hello.
Hello, good morning, Your Honor. Jara McLawrence.
Okay.
Most of that paperwork are notices to appear in probable cause affidavits. Judge, I have Jacqueline Garcia. She's over in North Broward.
Okay. Jacqueline Garcia, please.
Yes.
Good morning, ma'am. We have your attorney, Mr. McLawrence, here. Had an opportunity to speak to Ms. Garcia?
Yes, Judge, I did. I spoke to her about this 2018 KPS on municipal ordinance, possession of drug paraphernalia and alcoholic beverage, and she indicated to me that she would like to resolve this matter, Your Honor, if the court is so inclined. And I would ask if the court would withhold adjudication and take judicial notice of time served in exchange for a plea of no contest.
Thank you, Mr. McLawrence, for getting me the probable cause affidavits. I appreciate that. All right, so you're asking for what, sir?
For withhold and judicial notice of time served.
Time to pay?
Judge, I was going to ask for 6 months.
Okay, ma'am, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Jacqueline Garcia, Garcia?
Correct.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial?
That's correct.
Anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what's going on here today?
No, Judge.
Ever been treated for a mental illness?
No.
Okay, you want to plead no contest or not guilty or guilty to possession of drug paraphernalia and alcoholic beverage violation.
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily given. The court has reviewed the court file and finds probable cause for the plea. The court's going to withhold adjudication and impose court costs on count 1 of $78. I'll give you 6 months to pay. The court will withhold adjudication on count 2. And the court will give you 6 months to pay the $78. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, ma'am, except for paying the $78 in 6 months, okay?
Judge, I just wanted to clarify, the $78 isn't per count, it's for the entire
Just the
case,
one.
right?
Just one, yes.
Okay, thank you, Judge.
Thank you very much.
Judge, also at North Broward, there's Eric Redmond. He's on page 9 of the docket. I have it. Thank you.
I had Mancini, there's some Redmond. Okay, Eric Redmond. Do we know what page he is, you said?
He's on page 9, Your Honor.
Okay, page 9. All right, are you Mr. Eric Redmond, sir?
Yes, ma'am.
All right, sir, you're charged with a municipal ordinance violation, disorderly conduct. It was at the Elbow Room. What are we doing with this case?
Yes, Judge. I spoke with Mr. Redmond, and he indicated to me that he desires to resolve this. I would ask if, in exchange for a plea of no contest, if the court would either provide Mr. Redmond with a withhold and judicial notice of time served or an adjudication and time served, Your Honor.
Do you know anything about his prior history?
I do not, Judge. Say anything.
All right, the court will give him a withhold and court cost $78. Time to pay?
Judge, I was going to ask for 6 months as well.
Want to explain to him he can't return to the elbow room?
Oh, sure. Mr. Redmond, the court is resolving your case here today with a withhold, which means you won't be adjudicated, you won't be convicted, and $78 in court costs. One of the conditions is that you cannot return to the elbow room for up to a year, I believe.
Okay, yes, sir.
All right, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. Is your name Eric Stephen Redmond, R-E-D-M-O-N-D?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness, sir, that would affect your ability to understand what's going on here today?
No, ma'am.
Okay, you want to plead no contest to disorderly conduct?
Yes, ma'am.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to withhold adjudication, impose court costs, $78, give you 6 months to pay. Court takes judicial notice of the time you served in the Broward County Jail, and there's no return to the elbow room, sir. Good luck to you. You're done with this case, sir, except for paying the $78 in court costs. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you, sir.
Mr. Redmond, I'm not sure of your driving status, but you also need to know that with the $78 court costs, if you don't pay that within the 6 months, there's a likelihood that the clerk's office may file paperwork for the DMV to suspend your license if you have a driver's license.
Yes, sir.
Okay.
Okay.
Okay. Take
Thank
care.
you.
You're welcome.
Thank you.
Judge, I have two individuals at the main jail.
Mancini is the next one I have.
Yes, Mancini and Everett.
Okay.
And Mr. Mancini's on page 5 of the docket.
Okay, Michael Mancini, please. Good morning, sir. How are you?
Morning.
Sir, you are charged with panhandling. Okay, Mr. McLawrence.
Yes, Your Honor. I spoke to Mr. Mancini earlier this morning, Judge, and he indicated to me that he was just, he's homeless, Judge, obviously, and he was begging for food, begging for money so he could buy food. And he realizes what he did was not, is in violation of the city municipal ordinance, but he desires to resolve this matter, Your Honor.
The court will adjudicate in time served. Can't return to this area.
I don't know the area, Judge. I don't have...
Well, wherever he knows where he was arrested, so.
Mr. Mancini, the judge is offering you a time-served sentence, and the only caveat is that you cannot return to that area.
I can give you the location if you want it.
It's on 4th and Sunrise.
Okay.
It's 300 East Sunrise.
Thank you.
Is that what you want to do, Mr. Mancini? Would you like to take that offer?
Yes, I would.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Your name is Michael A. Mancini, M-A-N-C-I-N-I?
Yes.
Okay, it's my understanding you wish to waive your right to a trial.
Yes, I do.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness that would affect your ability to understand what's going on here today?
No.
Okay, you want to plead no contest, not guilty, or guilty to panhandling?
No contest, Your Honor.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court is going to adjudicate your time, serve you. Post court costs of $78, give you 6 months to pay. The court costs, you cannot return, sir, to 4th and Sunrise, okay?
Yes.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you.
Thank you.
Okay, and then the next one I have, you said is Calvin Everett.
Yes, Judge. He's on page 6 of the docket. He's also in the main jail.
I have an MO from Pompano and Hollywood. That's not you. Okay. Okay, Calvin Everett. Good morning,
Yes,
sir.
ma'am.
How are you?
Good morning.
Sir, you have possession of a controlled substance, which is a municipal ordinance violation. You did not show up at arraignment. What are we doing with this case, Mr. McLawrence?
Judge, he wants to resolve the matter. I would let the court know that he had a job interview recently, and he's due to start a demolition job this Friday, so that would be 2 days from now, Your Honor. So he's asking that his license not be suspended. So I would ask that the court would withhold adjudication and take judicial notice of the time served.
Time to pay.
6 months, Judge?
Sir, raise your right hand. Do you swear and/or affirm to tell the truth?
I do.
Is your name Calvin Everett, Everett?
Yes, ma'am.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication, or ever been treated for a mental illness that would affect your
No,
ability to
ma'am.
understand what's going on here today?
No, ma'am.
Okay, you want to plead guilty, no contest,
No
or?
contest.
Okay, no contest to possession of a controlled substance? No contest?
Yes, ma'am.
To possession
No
of a
contest.
controlled, you gotta let me finish the sentence though, sir. How do you wish to plead to possession of controlled substance, sir?
No contest.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's gonna withhold adjudication, impose court costs of $78. The court will give you 6 months to pay. The court takes judicial notice of the time that you served in the Broward County Jail. Thank you, sir. Good luck to you. You're done with this case.
Mr. Everett, also, Mr. Everett, just remember that the judge gave you 6 months to pay the court costs. If you don't pay those court costs within 6 months, there's a possibility that the clerk's office may file paperwork with the DMV for your license to be suspended. So it's just $78. Try and pay it within the 6 months.
Yes, ma'am.
Thank you, Mr. McLawrence. All right, we're gonna go back. Hi. Do you have a case you'd like us to take, or we can wait a little bit, but? Oh, good morning. So what's the name of the case? Spell the last name? What page is that on?
No, I got it. I gave her.
Page what?
See, you want to keep all these things.
Oh, okay. Thank you. Yes. All right, so Shanqueta Cherry.
Miss Cherry is in the North Broward Detention Center, Your Honor.
Okay, Miss Shanqueta Shakender Cherry.
Yes, Judge. I'm going to be asking the court to consider.
Well, she's not here yet.
Oh, she's
though.
not there yet. Okay. Well, then
North
I won't be
Broward,
asking for
We have
anything.
Miss Cherry, Shanqueta Cherry.
You're on medical reset.
Really? I was just talking to her. Is she all right? Hold on. Let me
She
call you.
is.
Let
She's
me call you,
pregnant. She
Deputy.
wasn't.
She wasn't feeling good? Okay, we'll reset it. Thank you. Next one is going to be Tammy Chera Johnson.
Also on medical reset, Your Honor.
Thank you. Moving right along. Lysandra Lavette Johnson.
Reset.
For what? Medical? A lot of medical resets. Sabrina Morris.
Ms. Morris. No problem, Your Honor.
Thank you. Hey, are you Miss Morris, ma'am?
Yes, hi.
Hi, good morning. You have a battery on an officer firefighter We need to talk about bond, and then we have resisting an officer or obstructing with violence. We need to talk about bond. Any objection to probable cause?
No objection to probable cause, Judge.
Okay, the court does find probable cause.
Judge, I'm going to ask you to consider pretrial release for Miss Morris. She's been a resident here of South Florida for all of her life. She has family here, including her mother and father, and that's where she would be living with her mother and father, where she has lived all of her life. I don't believe that she has an extensive prior criminal history, if she has any criminal history at all. So I think that she would be a very good candidate for pretrial release.
State? Okay, standard pretrial release. Okay, ma'am, the court's gonna place you on pretrial release.
Okay, thank you.
Hold on a moment. Doesn't have an
Okay.
address. How is she gonna get notice? Yeah, I don't know which one the clerk has.
What's your address, Miss Cherry? Miss Cherry? Miss Morris, I'm sorry.
Thank you. 5881 Northwest 16th Place, apartment 226, Sunrise, Florida 33313.
Okay, ma'am, and Mr. Reedy, you might wanna tell her she has to report by tomorrow.
Yes, they're going to give you a map as to where you report. It's right here in downtown Fort Lauderdale, across the street from the courthouse. You need to report within 24 hours of your release. Okay? All right?
Thank you.
Okay, good luck.
Okay, thank you. Bye-bye.
Okay, Dino Anthony Mazzola, please.
Mr. Mazzola is here present, Judge at Maine.
Okay. Back again to you, Mr. Romero. Okay, we have Mr. Mazzola, trespassing, unoccupied structure or conveyance. Any objection to probable cause?
No, there's no objection to probable cause, although it does concern me a little bit.
All right, the court's gonna find probable cause. Does anybody want to be heard with regard to the bond?
I'll let State go first, Judge.
Your Honor, if he wants to resolve this one, the state would be offering an adjudication of 5 days, Broward County Jail. He does have a previous trespass from the same location exactly 1 month ago today, February 21st, and he's also on pretrial release currently for a battery on law enforcement charge and a trespass charge.
So if he has a felony, how can we resolve this? Okay, tell me what you're asking for, Mr. Romero.
Judge, as my colleague pointed out, as far as the, I find this troubling. According to the PC affidavit, basically Mr. Mazzola was arrested because he was trespassed at that Chevron gas station. There were certain things that were omitted. He actually called 911. He realized he was having some sort of mental health issues. He was having suicidal thoughts. He was calling 911 to get Baker acted. When he was on the phone, the 911 operator told him basically, stay on scene. We're sending a unit to come and talk to you. He stayed on scene, and rather than that unit basically taking the appropriate, actions, that officer decided to arrest Mr. Mazzola. That's what I find alarming and troubling. Judge, there was a person that needed help, reached out 911 in the appropriate way, requested to be Baker acted, and he was arrested for trespass. I think he failed to look.
What are you looking for, Mr. Romero?
Judge, he's not going to resolve this case. I mean, this is something I advise him not to resolve. We're going to be transferring it to. I would ask you to transfer it to Judge Lerner Wren. He advised me at this time he doesn't have anyone that posts his $25 bond. I got to make a note on his behalf to request ROR, but I certainly understand if Your Honor doesn't want to ROR and leave the standard bond in place so he can go in front of Judge Lerner Wren and hopefully get the help that he initially sought by law enforcement kick the ball over to you.
State has no objection to transfer them, Judge Lerner.
Okay, let's transfer this to Lerner Wren, and you're gonna call Mr. Linder? Okay, all right, so he'll go to Lerner Wren, sir. There is no return to the Chevron, 1625 South Federal Highway, Hollywood, okay? Thank you. I have the order right here, okay?
He's here present, Judge?
One moment.
Let me see. Oh, yeah.
Okay, Michael Herbert.
He's here present, Judge. He declined to serve the public defender.
Okay, Mr. Herbert, you have disorderly conduct. Court does find probable cause. $25 bond. Can you afford to pay that?
No, Judge.
Your Honor, you found probable cause? Jackson comes to trial, Your Honor. He's currently on pretrial on case number 18-2287MM10A. This new charge is violation of conditions of pretrial.
What's his charge on the 2287?
Resist officer, obstruct with violence. Count 2, trespass, fail to leave property.
Wait, this is an MM, so it's resisting without.
With, what is it, obstruct without? I gotta double check, Your Honor, I apologize.
Yeah, if it's an MM.
Probably is. You're absolutely right, Your Honor.
He's also out on 2 other cases before Judge Gottlieb. One for trespass, actually 3 other cases. One for trespass, one for resisting without violence, and the third for trespass in front of Judge Gottlieb, in addition to the case he's out on pretrial for. He just got out, I believe, 4 days ago to pretrial. There's really
Can you hear him, sir?
Judge, I just want to waive counsel. I want to demand for speedy trial. According to Florida Rules of Criminal Procedure 3.191, I want to demand for speedy trial, and I want to have a trial by jury in all cases.
Your Honor, our office represents Mr. Herbert on his pending cases, and he has a hearing scheduled, it looks like June 7th of 2018 to address issues of competency, and that case is currently assigned to Judge Gottlieb, but maybe it should be assigned somewhere else.
Well,
She won't take these charges, I don't think.
and just because there's competency issues doesn't mean it automatically qualifies,
No, I understand that. I'd ask the court not to take any action on Mr. Herbert's case at this time, Judge. As his attorney on his other cases, even if he has declined the public defender on this case, we still do represent him on his other cases.
I would request trial by jury in all cases as soon as possible, within 60 days at least, so I can be able to get my property back from the police station. All my property. And according to Florida Rules of Criminal Procedure, I have a right to demand for speedy trial according to 3.191. I'm ready to invoke that right now.
Okay, sir, Mr. Reedy will tell you that you should put it in writing, but In any event, sir, this is what I'm gonna do. I am gonna defer to his division judge on pretrial's request to revoke his pretrial. And the court's gonna leave the $25 bond in place. Thank you, sir.
Thank you,
We have
Judge.
other pending cases. Herbie Crucial?
Medical reset, Judge.
Oh, that's an MO, okay. Chris Charles Hilker?
Mr. Hilker? He's coming, Judge.
This is an MO out of Hollywood. Oh, you're right.
He's approaching, Judge.
Good morning, sir.
Good morning.
Okay, is your name Chris Charles Hilker?
Yes.
All right, sir. How you feeling today? Did you just wake
All
up?
right. No.
No? Well, you're being charged, sir, with no lodging on city-owned property.
Didn't I already go to court for that?
Maybe on another case, but not this time. You were just arrested. Let me ask you something. Is this a case that would be appropriate
When was
for...
I arrested? You mean yesterday?
Yes. You had an
I've
active
been
warrant.
charged with, they said I had a warrant when I was arrested yesterday on a sidewalk.
Yeah,
He was arrested on a warrant yesterday.
on a no-show at arraignment. Is this appropriate?
And
to
I was
trans-
on a sidewalk. I was on a sidewalk when they said I had a warrant.
Okay. Mr. Reedy? Do you think that...
I really can't say much, Judge. It's a municipal ordinance, but I don't think the court would be out of bounds to ask the state what they thought. Although I guess the state really can't say much either.
All right, give me the... All right, can I have an order for Lerna Wren? Okay, sir, the court's going to keep the bond at $100, and we're going to transfer you to Judge Lerna Wren. I got one.
What am I charged with?
You're charged with lodging on city-owned property. Mr.
Where at?
Linder, I know you don't
Where
get
at?
involved, but can you be, as a friend of the
Where at?
court?
I can let her JA know, I just can't make a recommendation.
Okay, that's fine. I'm sorry, sir, what did you say? All right, sir, we're going to transfer your case to Judge Lerna Wren. Okay? Thank you. Okay, Mr. Romero, can you... Next case, Emmanuel Navamule.
Mr. Emmanuel Navamule, Judge, he's here present, may he decline the service of public defender, Judge.
Okay, sir, you have possession of marijuana, not more than 20 grams. Bond is set at $100. The court does find probable cause. Can you afford the $100 bond, sir?
Yes.
Okay, who's gonna bond you out?
I'm not sure yet. Either my brother or my father.
Have you spoken to them?
Not yet. I haven't had a chance to have a phone call.
If he wants to resolve it today, the state's offer would be a withhold. And
Okay,
court
if you
costs.
want to resolve your case today, you don't have to. The state attorney is asking for a withhold of adjudication, which means no conviction. the court would have to pose court costs of $308, and I could give you up to a year to pay.
No, it's all right.
Okay, so $100 bond. Thank you, sir. Jonathan James Blomquist.
Mr. Blomquist is here, present judge at Maine.
Okay, Mr. Blomquist, you are charged with one count. Trespassing property, not a structure or conveyance, $25 bond. You also have a municipal ordinance of drinking on the beach.
Judge, in speaking to Mr. Blomquist, he wishes to ask Your Honor if you would consider resolving his case today and offer him adjudication time served.
State?
Your Honor, state has no objection.
Okay, if he agrees not to return.
He says he agrees, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, is your name Jonathan James Blomquist, Blomquist?
Yes.
Okay, it's my understanding you wish to waive your right to an attorney and trial in the municipal ordinance case, and you wish to waive your right to a trial in the trespass property, not a structure or conveyance case. Is that what you wish to do, sir?
Yes, I'd like to resolve the case today.
Both of them?
Yes.
Okay, and you want to waive your right to an attorney in the municipal ordinance case as well, sir?
Yes.
Okay, is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
You ever been treated for a mental illness that would affect your ability to understand what's going on here today, sir?
No.
You understand that if you're not a U.S. citizen, a plea to discharge could result in deportation proceedings and affect your ability to remain in the United States?
Yes.
Okay, understanding what I just explained to you, are you pleading guilty or no contest to trespass property, not a structure or conveyance?
No contest.
Okay, and what about drinking on the beach, sir?
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you and time serve you. The court's going to impose $78 in court costs in the municipal ordinance case, give you 6 months to pay. And then in the trespass not a structure case, count 1, or case 1, the court is going to impose, which I have to by law, $293 in court costs and give you 1 year to pay that. You cannot return to this location, sir. Do you understand?
Yes.
Okay, good luck to you, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. Joseph Pierre Muner.
I believe North Broward, Judge.
Okay, all right, and then we're going to take a case out of turn. We have a private attorney here. All right, Joseph Pierre Muner. M-E-U. Bond posted, okay. All right, can I have that, Michelle, please? All right, then we're going to call Austin Dwayne Lewis.
Morning, Your Honor, again.
Okay, all right, Mr. Lewis, we have your private attorney here. Counsel, announce your appearance for the record.
Valerie Small Williams standing in for Attorney Lisa Stewart. Your Honor, Mr. Lewis, I believe his case is in front of Judge Uson, if I'm not mistaken. If I don't have a probable cause argument, I reviewed the PC on the case, but I'm going to ask the court if the court can get Mr. Lewis on Judge Uson's docket for Friday morning.
Okay, well, this is what I have for you.
That's what a VOP is?
So, all right, so let me just start from the top, folks. Mr. Lewis, you're charged with 1 count, petty theft, first degree, between $100 to $300. Bond set at $100. Defrauding a financial institution, $3,500. Counts 3, 4, and 5 are the same, which is use or possess ID of another without their consent, $1,000 bond each count. And then you have count 6, 7, and 8, which is possess, receive, retain a stolen credit or debit card, $1,000 bond. So the total bond is 1, 2, 3, 4, 5, 6, 7, 8, 9, 9,500, 9,600. You also do have a count 9, sir, which is a probation violation or community control, and you're going to be held no bond on that count. You are going before your division judge, who is Judge Michael Usan, on March 26th, which is actually this Monday is when the judge set it, at 9 a.m. If you want to try to set it at an earlier time, you can call Judge Usan's office.
Yeah, I'll instruct Ms. Stewart.
Okay. All right. So court does find probable cause. Anybody want to be heard with regard to the bond?
Judge, in light of the fact he's being held no bond, I would just ask the court to reconsider the $3,500 bond and make that one $1,000 also.
Okay, State.
That's fine, Your Honor.
Okay, so court will do $1,000 bond. I am going to order no victim contact, direct or indirect, with the alleged victim, sir, with the initials LFK. Direct or indirect, sir, means no contact in person, through calling, texting, social media, liking, disliking anything or the like, and also no contact through third parties. Do you understand?
Yes, ma'am.
All right, so the court will keep all the convenience bonds in place, except for count 2, per the state and the defense. Bond will be set at $1,000, and you are going before your division judge unless your attorney can change it on March 26th, which is this Monday at 9 a.m. Good luck to you, sir.
Thank you, Your Honor. Appreciate your time.
You're welcome. Have a good day. Nice seeing you. All right, Donnie Marcellus Thomas.
Mr. Thomas is here. Judge, he declined the services of public defender.
Okay, Mr. Thomas, you are charged with procure for prostitution, solicit another for a lewdness act. Court does find probable cause. Bond is set at $300. Can you afford that, sir?
Yes.
Okay, who's going to bond you out?
I was doing self bond.
Okay, does he need an order to self-bond? Mr. Reedy, do you know? No?
Shouldn't
Okay.
he shouldn't, Judge.
All right, sir. Good luck to you.
Thank you.
Thank you. Richard Charles Krupleski.
Mr. Kapelski is here present.
Okay, Mr. Krupleski, how are you this morning, sir?
Good, how are you?
Good. You have one count of petty theft, first degree, between property with a value of between $100 and $300. Bond's been set at $100. Any objection to probable cause?
No, Your Honor.
Court finds probable cause, sir. The court's going to order no return to the Home Depot, which is located at 1000 Northeast 4th Ave. Do you understand, sir?
Yes, ma'am.
All right, so what are we doing with this case, Mr. Romero?
Judge, in speaking with Mr. Kapelski, he wishes to ask the court if you would consider resolving this case. As you said, I believe it happened at a Home Depot in which merchandise was recovered, so no restitution issues. So we'd be asking for an adjudication time served on Mr. Kapelski's behalf.
State adjudication time served on Krupleski. No return to Home Depot.
Your Honor, state will be requesting adjudication 5 days. He does have multiple petty thefts out of county, in Tennessee, Pennsylvania, and
Okay, they're requesting 5 days Broward County Jail with credit for time served.
Judge, my understanding this is his first time being arrested in Broward County, I believe maybe in the state of Florida. I believe his priors may have some date to it. So, Judge, I believe adjudication time served would be reasonable. So I'm asking the court if you would consider extending an offer adjudication time served, Judge.
Okay, let him do it, Eric. Go ahead.
In Tennessee, there's a 2017 theft and a 2015 forgery. And then in Pennsylvania, there's a theft, a 2013 theft. There's also a theft from 2012. Another theft from 2012. Yeah, so there are theft charges from Tennessee and Pennsylvania.
Over a year ago, Judge. Like I said, doesn't change. First offense here in Broward, in Florida, I believe, as far as the theft. Judge, I would ask you to consider time served.
Court will do 3 days. Credit for time served. Does he want it?
Yes, Judge,
What's
you will.
the court cost on the petty thefts, Madam Clerk? Is that $293? Okay. Time to pay?
One year, Judge.
Okay, sir, you spoke to him also, Mr. Romero, that if he gets 2 of these, he can be charged with a felony?
Yes, Judge.
It's probably if he gets another one, this one. Okay, raise your right hand, sir. You swear and or affirm to tell the truth?
Yes.
Okay, Richard Charles Kropleski, Kropleski is your name, sir?
Yes.
Okay, put your hand down. Is my understanding you wish to waive your right to a trial in this petty theft case, sir?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No. I think she said ever had a mental illness. Yes, I do.
Okay, is your mental illness affect your ability to understand what's going on here today, sir?
No.
Okay, understanding what I just explained to you, you want to plead guilty or no contest to petty theft, first degree property, between $100 and $300.
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you, sentence you to 3 days, Broward County Jail with credit for time served. $293 in court costs. The court will give you 1 year to pay that. No return to the Home Depot, sir, at 1000 Northeast 4th Ave, Fort Lauderdale, Florida. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you.
Good luck, sir.
Okay, which case are we here on, sir? We have another private case. Sorry, Mr. Romero.
16,
No problem.
Mr. Gonzalez.
Okay,
Yes.
Hayato.
Yes.
Gonzalez Ortiz, please.
Yes, Your Honor, thank you.
Gonzalez Ortiz.
Oh, Steve Plantford.
Okay.
North Broward.
Okay, good morning, sir. Is your name Haithalo Rodur Gonzalez Ortiz?
Ethan Rodriguez Gonzalez Ortiz. Yes, ma'am.
Okay, sir, we have a private attorney here. Counsel, announce your appearance for the
Yeah,
record. and then-
Steve Plant, his attorney is Mr. Yamuno. He's a Miami attorney.
Okay. All right, state if you can announce your appearance for the record, please.
Eric Linder on behalf of the state.
All right, Mr. Gonzalez Ortiz, you're charged with count 1, grand theft, between $300 and $5,000, bond set at $1,000. Grand theft auto, $1,000 bond. Count 3, false owner info bond. Items $300 or more, $3,500 bond. Dealing in stolen property, which is count 4, $3,500 bond. So now we're up to $9,000. And then
Thank
we
you, Judge.
have count 5, we need to talk about bond. It's burglary of an unoccupied conveyance unarmed. And then we have count 6, petty theft, second degree, first offense, $25 bond. Any objection to probable cause?
Oh, Your Honor, I read the lengthy PC.
Okay, the court
7
does find
pages.
probable cause. The court is going to advise you, sir, that you can have no victim contact, direct or indirect, with the alleged victim in this case with the initial CP. That means no calling, texting, anything through social media or third parties. You understand, sir?
Yes, ma'am.
Okay. So that also means no in-person contact. All right, State.
Your Honor, the state is going to be requesting a bond on count 5 in the amount of $10,000. Pre-trial release of the GPS monitor. Mr. Gonzalez Ortiz is currently out on bond for 2 counts of grand theft, and that also involved, it was vehicle related. He's charged with stealing between $300 and $5,000, 2 counts worth of tires and rims from a victim's vehicle, and in the other charge, airbags of a different alleged victim's vehicle.
But this says this was in 2015.
Yes, Judge. I understand. I'm not saying it revokes his. I'm not saying it violates his release conditions. My concern is it's ongoing criminal behavior.
I understand.
And it also involved, it seems to be a common MO involving people's vehicles.
Okay. All right, defense.
So we were at 9,025 already for the bond.
Yep.
I don't know if they want another 10,000 for the same case.
$19,025 if my math's correct.
Yeah, 9,000. Yeah. So I'd seek another just around it, another 1,000, since it's really one piece. It's one incident, one case.
Okay, so total bond.
To make it or 1,000. I just thought 10,000 would be excessive to put him at 20,000.
All right, this is what the court's going to do.
And then obviously pre-trial is fine.
No victim contact, GPS level 2. What does your client do for a living? What do you do for a living, sir?
I work with my mom. Mom has her own cleaning company.
Okay, I'll do a GPS level 2 open schedule.
Your Honor, we're going to ask that he can give a schedule to pretrial. We'd ask that it not be open, considering he's out on a felony involving stealing tires, rims, airbags from someone's vehicle. He's allegedly here on a theft of someone else's car. I think it's reasonable to know where he's going to be.
Okay, court's going to keep an open schedule, Mr. Linder, respectfully. Count 1 is 1,000. Count 2 is 1,000. Count 3 is 3,500. Count 4 is 3,500. Count 5, the court is going to do a $2,500 bond, and count 6 is going to be $25. Thank you, sir. Good luck to you.
Thank you, Judge. Thank you, Mr. Gonzalez.
Any others, Mr. Plant? Nice seeing you.
I don't, unless Hollywood, Mr. Shate might have something, but
We did have something for Hollywood, but
it was done. Okay.
I resolved it, yes.
Okay. Thank you, Judge. That's it.
Hold on one moment.
Judge, there was, I believe, one gentleman that I saw that was a 40, MO40.
That would be it.
That would be out of, Hollywood. Judge.
Yes, Mr. Romero. Thanks for the.
And that was Mr. Chris Tucker on page 5, in which you transferred his case to Lerner Wren. I don't know if you would be wanting to go ahead.
No, we transferred his case to Lerner
Chris
Wren.
Hickner. Thank you anyway, Judge.
Okay.
I'll come earlier, I guess, next time.
All right, thank you.
Thanks. They don't tell me.
Okay. All right, Marquise Tyrell Wilson.
Mr. Wilson is here present, Judge, at Maine. Come on up, Mr. Wilson.
Okay, good morning, Mr. Wilson. You have resisting an officer without violence, $100 bond, and you have a KPS traffic, which has a $250 bond. That's for driving while license is suspended. Any objection to probable cause?
No, Your Honor.
Okay, court finds probable cause. He did no show for arraignment, Mr. Romero. So anybody want to be heard with regard to the $350 bond?
I do, Judge. And speaking of Mr. Wilson, there's more than meets the eye. I haven't had an opportunity to review the probable cause affidavit, but he's looking forward to his day in court, and he wants to very much fight, and he disputes the allegations on count number 1. Having said that, Judge, right now he's homeless. Unfortunately, he just lost his job. He was working at Dayland Mall at a burger place. Unfortunately, now he has no income coming in. There's no one from what he advised me that has the financial resources to post his bond. However, he does have a mailing address. Judge, from what he advised me, he did not know as far as his court date in reference to number 2. Judge, at this time, he's asking Your Honor if you would consider releasing him on standard pretrial. He's been here his whole life. He's 24 years old, Judge, and we'd be asking you to sign a photo order so we could photograph Mr. Wilson's injuries that he sustained.
Okay, the court will grant your photo order, Mr. Romero. State?
Your Honor, we just want to bring to the court's attention that he does have the habeas out of Miami date as well. And so we would object to the pretrial.
Okay, he doesn't show up for court, Mr. Romero, and I don't want him to resolve his case today. I know he wants his day in court, which is fine, but the court will do this. On count 1, the court will ROR, but on the count 2, the court's going to leave it at $250. Okay? All right. He has to update his address once he knows it, or check online. All right, next one is Jacob B. Dewan Small.
Mr. Small?
Okay, Mr. Small, you have 2 habeas misdemeanors. One is operating without a valid license, $250 bond, and then you have driving while license canceled or disqualified. First offense, $500 bond. Court does find probable cause. Anybody wish to be heard with regard to, there's $250 and $500.
Judge, in speaking with Mr. Small, he wishes to ask the court if you would consider resolving both matters here today.
State? He doesn't have any felonies pending, right?
No, Judge.
Okay, what are you looking for?
Judge, I'm asking for time served. These are 2015, 2017, so at least over a year old. So I'd ask you to consider adjudication time served.
State, do you agree?
Yes, the state agrees, Your Honor.
Okay, raise your right hand, sir. You swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, your name is Jacob E. Dewan Small, S-M-A-L-L. Put your hand down.
It's Jacoby, but yes, ma'am.
Okay. Jacoby, I'm sorry.
It's all right.
It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No.
You understand that if you get 3 convictions within 5 years of driving while license is suspended, they're going to suspend your license and revoke it for 5 years as a habitual traffic offender?
Okay, I'm planning on getting it worked out as soon as I get touch the streets, ma'am.
Okay, but you understand that if you get 3 convictions within 5 years, your license is going to be suspended for 5 years as a habitual traffic offender. You understand that?
Yes.
Okay, so they revoke your license for 5 years. Okay, understanding what I just explained to you, you want to plead guilty or no contest to, in the 2015 case, it's operating without a valid license. 2017 case, driving while your license is canceled or disqualified, first offense, sir.
Yes.
No
contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate and time serve you on each one. $293 in court costs on each case. Court will give you 1 year to pay. If you don't pay, sir, Mr. Romero will tell you what happens with regard to your driver's license, okay? You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed, sir. Good luck to you, okay?
Good luck, Your Honor.
William Allen?
Mr. Allen, come on up, please. He's here present, Judge at Maine.
No. Okay, sir, you are charged with 1 count of loitering and prowling. The court does find probable cause. You're pulling on car handles. $25 bond.
Judge, in speaking with Mr. Allen, he wishes to ask the court if you would consider resolving his case today for time served. My understanding is he's been in a medical reset for a couple days now. From what he advised me, he's currently living at First Step Sober House, which is in Pompano. He really much wants to go back to finish up his treatment. But on this case, he's wishing to put this behind him, and he's wishing to ask the court if you would consider adjudication time served on this second-degree misdemeanor.
state is concerned, the offer would be 15 days. I don't know if you remember, Mr. Allen. He was arrested on March 8th. He was medically reset then a couple times on a criminal mischief. He was given an ROR. In that allegation, he, shattered the glass attached to a bus bench. And he pushed a shopping cart into the glass, shattering it.
This was before or after 3/18?
This was before. He was arrested.
The incident you're talking about, when was that?
The criminal mischief, he was arrested March 8th, and he's also out right now on a burglary conveyance. He has a robbery by sudden snatching in 2016, where he violated his probation, and a theft in 2015.
Judge, in the alternative, Judge, I do understand the court's concern when a gentleman has a pending felony case. Would Your Honor consider an ROR so that he could go back and finish up his continuous treatment at First Step Sober House?
No. Court will do standard pretrial with ROR and standard pretrial.
Let me inquire.
For the record, the state would be objecting to an ROR to standard pretrial. I don't believe the community is being protected. Your Honor, he's out already for breaking into a car. He's here today for essentially attempting to break into cars. And in between the two, he's got ROR just less than a week ago, or about a week ago, for damaging property.
If he bonds out for $25, hold on. If he bonds out for $25, at least with standard pretrial, he's reporting twice a week with phone calls.
I wasn't going to be requesting a $25 bond.
Well, I didn't hear that you were requesting anything more. So what are you requesting?
I'd be requesting a $500 bond, Your Honor, because essentially this is based on the allegations. It's basically attempted burglary.
Judge, he wishes to accept the court's offer as far as being placed on pretrial release so that he could go to First Step Sober House.
God bless you.
I go to First Step and do pretrial and report. It's been a rough month for me.
Okay, court's going to put him on standard pretrial. He's got to report 2 times a month in person.
Yes, Judge, and I'll give him the map right now.
You have a court date March 23rd, Mr. Allen. Don't miss it.
Here's the other thing. He's going to have to still call in twice a week. And you're going to have to explain to him, Mr. Romero, he has to report by 24 hours of his release, or by tomorrow, actually, okay?
Thank you, Judge.
Thank you. Valerie Podoliski.
Conti. Your Honor, hello. He's in courtroom 4780 this morning.
All right, so we resetting it for this afternoon, folks, or tomorrow?
Tomorrow would probably be better. He was here yesterday, wasn't he?
Well, this is a KPS felony. It's an ad charge.
Right.
It's in front of Judge Lynch.
I'd ask you to reset him for tomorrow, Your Honor.
Okay, we'll reset for tomorrow. Who else do you have? Hello.
I have from yesterday Elijah Moran and Billy Martin.
Hey, what's up, Bones?
I have Billy Martinez. What page is Moran?
Unfortunately, he is the last page.
Okay. All right, so let's take your 2. Billy
I think
Martinez.
it might be up there.
Hello, how are you?
Good morning.
Hi, sir. All right, you're Billy Martinez?
No, ma'am.
Yeah, I think so.
We'll call you in a second, sir. Okay, sir, your name is Billy Martinez?
Yes, ma'am.
Okay, sir, you have some ad charges, KPS felonies. You need to talk about bond on count 2, which is burglary of a structure unoccupied. And then counts 3 and 4 are felony petty theft, bond set at $750 each. The court does find probable cause. I can tell you, you do have a court date before Judge Andrew Siegel on this Monday, March 26th at 8:30 a.m. State, as to count 2, or charge 2, the ad charge.
Bond was originally set at $5,000. This is actually a change of charge. I'm asking that the bond be kept at $5,000. He was arraigned on Monday by Judge Siegel.
Should be up there.
Oh, I see. Ad counts 3 and 4 and change of charge 2.
Yes.
All right, defense, Mr. Reedy, there,
Well, I believe he has a no bond hold, Judge.
he does?
Is this Mr. Martinez?
Yes.
Yes, he has a no bond hold on count 1. I'd ask just for a reasonable bond on count 2, Judge. He has a court date of March 26th at 8:30, and he'll be going in front of his division judge at that time to resolve these matters.
Okay, so this is what the court's gonna do. The court's gonna put your bond on count 2, $4,999, and you can resolve it with your division judge, okay, sir?
Okay.
Thank you, good luck to you.
Oh, wait, they did. Sorry, I got it.
Do you need to Bye. Yes. Okay, so that's Billy Martinez. Are you Elijah Moran?
Yes, ma'am.
All right, finally, sir. So you have some ad charges. Count 14 is petty theft, second degree, ROR. And then 19, and it has 18, believe it or not, is 2 KPS felonies. Burglary dwelling, hold on, burglary dwelling occupied and burglary unoccupied dwelling. Is that correct, State?
Yes, ma'am.
All right.
State's requesting a $10,000 bond, Your Honor, on each burglary count.
Okay, so State is requesting, anything else State's requesting?
No victim contact. And he's being held no bond on other counts, Your Honor. And you
Okay, what's the
previously
initial,
set a
the
$10,000
victim's
bond.
initials, please?
Sorry.
You have to be sorry, Mr. Linder does it all the time, too. Okay, sir, I'm gonna give you the initials of the alleged victim in this case. There's no victim contact, direct or indirect, which means in person, calling, texting, through social media, liking, disliking anything, or any contact through third parties. Do you understand?
Yes, ma'am.
Okay.
One of the victim's initials is JS.
Okay, and the alleged victim's initials in this case is JS.
And the other victim is SY.
Okay, so it's JS and SY, 2 different people, okay, sir?
Yes, ma'am.
All right, so let's talk about bond defense on counts, it says 19 and 18. Yes, that I know. But 18 and 19, burglary occupied dwelling and burglary occupied dwelling and burglary unoccupied dwelling.
Mr. Moran, I believe, has a number of no bond holds, Judge. I'd ask you to set a reasonable bond so we can get in front of his division judge and resolve these matters.
Backman?
Yes, I think it is Judge Backman, actually.
Okay, this is what the court's gonna do. The court's gonna set his bonds, and I'll put a notation on here. Count 19 and 18 for the burglaries, $9,999 on each count, okay?
Okay. Excuse me, Judge.
Don't talk about the facts of your case, though, okay?
I'm not. I've been coming to magistrate every day for like the past
roughly 3 weeks, and I was just wondering if you were to call me again, can I waive my appearance? Because I have several no bond holds, so it really doesn't matter.
Okay, Mr. Reedy? Doesn't matter to me.
Well, I mean, you can if you want to, Mr. Moran, and nobody's gonna, drag you kicking and screaming. I would miss you if you didn't show up. But, you may want to show up just to find out exactly what it is that's being charged against you. You might, be some information that you could use.
I would rather just waive my appearance, sir.
Well, Elijah, just tell the deputies that you would prefer not to attend, and if that's really what you want to do, it would be against my advice, but if that's what you want to do, I think you're within your rights to do it.
Yes, sir.
Okay.
Good luck, man.
Thank you, Mr. Moran. Have a good day. Good luck to you.
Your Honor?
Yes.
Thank you. The last person on the docket, Mr. Williams, Devon, he's in courtroom 4780.
Okay, hold on. Devon Williams, you said?
Kevon, Kevon.
What page?
He's the very last person, 21.
He's the next to last case on the docket. It is a change of charge.
But he's in 4180 this morning. Thank you.
Okay, so we'll just reset him for tomorrow.
Yes, ma'am.
And that's it?
Yes, ma'am.
All right.
Thank you again.
See you then. All right, so the next person is going to be Johnny Mac Brown, please.
All right, Your Honor. How you doing this morning, Miss Kim?
Good, how are you, sir?
All right.
All
How
right.
you doing?
Good. Thank you for asking, sir.
Yes, ma'am.
All right, you have count 7, petty theft, second degree, third or subsequent offense. They're charging it as a felony, even though it's a petty theft. This is a capias not in custody. Bond set at $750. Court does find probable cause. State.
Yes, Your Honor.
Or anybody, does the defense wish to be heard with regard to bond?
Sorry, Judge. Who is this gentleman?
This is Johnny Brown. I'm sorry, yeah, Johnny Mac Brown.
Oh, Johnny Mac Brown. No, Judge. Mr. Brown, unfortunately, has a couple of no bond holds for some violations of probation. I'd ask you to leave the bond at $750. Let him go in front of his division judge and work everything out there, right, Mr. Brown?
Well, whatever.
Okay, well, whatever.
Whatever the court request.
I don't know if we have a court date for it.
That case now?
He has a no bond hold.
Is a violation of probation from what I'm showing.
Administrative probation.
Okay, well, either way, it's still a no bond hold, Mr.
Okay,
Brown.
court's gonna set his bond at $699. All right, sir, thank you, good luck to you.
Yes, ma'am.
Okay, Carlos Ricardo Ortiz. Do you have anybody else at Paul Ryan, deputy?
No, Your Honor, thank you.
Thank you, see you at lunch maybe. All right, Carlos Ricardo Ortiz.
Mr. Ortiz, is your present judge a Maine?
Okay, Mr. Ortiz, you have count 1, trespass, property not a structure, no bond attached to that, misuse of 911, no bond attached to that, and corruption by threat, public servant, or family. Any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause. We need to talk about bond on count 3, but first, sir, I'm going to tell you there's no return to the Highlands Plaza. Do you understand? Do you understand that, sir? Okay, I can't hear him, Mr. Romero.
Yeah, I was just trying to grab the phone and
I understand.
work the mic all at the same time.
Sorry. Sorry, Hector, I won't bother you.
Position here, it's almost impossible to reach for me, so it's a whole ordeal me getting the phone.
Okay, I'll give you a moment, but I just want to make sure he understands verbally so it's recorded that he cannot return to Highlands Plaza, 4801 North Dixie Highway, Deerfield Beach, Florida. You understand that, sir, correct?
Yes, ma'am. Yes, ma'am.
Okay. All right, Mr. Reedy, go ahead and call Mr. Romero.
Thank you, Judge.
Your mic off? Your mic off? How you doing, Sheila? It's almost Friday. Oh, that's good.
We're ready to proceed, Judge.
Okay, all right, so state, count three.
Your Honor, the state's requesting a $25,000 bond, count three. Pre-trial with the GPS monitor. No firearms, weapons, or ammunitions while on pre-trial.
Okay, defense.
Judge, in speaking with Mr. Ortiz, he's 41 years old, been living here his whole life. Unfortunately, at this time, he's financially indigent. However, he is working. He works for a Trojan labor pool. He's been there for about 2 years, making minimum wage. Unfortunately, at this time, because of his financial hardship, he is homeless at this time. So he has no one to post bond, and he doesn't have the ability to post his own bond. He does advise me, though, that he does have a mailing address, which is in Pompano, so he can receive future correspondence. Judge, I'd ask you to take all that into account and determine a reasonable release conditions for Mr. Ortiz.
What's the problem I had? It says he stated to the police officer he will continue to enter the plaza whenever he desires. And also, he threatened the police officer. So...
I understand the allegations, Judge.
Okay, court's gonna set a $5,000 bond on count three, GPS. Does he have a place to live?
No, Judge, he's homeless, Judge.
Okay, if he can bond out, pretrial release. He's to report 2 times a week in person. I wonder where that's coming from, North Broward?
This is going to confuse people.
Daniel Marico.
He's here present, Judge.
Okay, Mr. Marico, you have assault on an officer firefighter, $100 bond. Battery on an officer firefighter EMT. We need to talk about bond. 3 is disorderly intoxication, $25. And then harm public servant or family, $3,500. Any objection to probable cause?
No, Your Honor, but this is another probable cause affidavit that does concern me.
Okay. Court does find probable cause. Let's talk about bond state.
One moment, Your Honor.
Is that noise coming from you, Mr. Romero?
No, Judge.
Okay,
I believe
let me go to...
maybe North Broward.
I think it's Paul Ryan. It's Paul Ryan. Can someone call Paul
Oh.
Ryan and tell him to turn off their microphone? Maybe Sheila, you can have some luck. Paul Ryan, their lights are going off. You can have them turn off their microphone in the little room there. I'd appreciate it so much. Okay. right, so State, what are you requesting?
State will be requesting a $5,000 bond, Your Honor. He was
On
arrested.
count 2 and leave the other bonds in place?
Yes, Your Honor.
Okay, any special conditions or anything?
Just want to bring it to the court's attention. He was arrested 4 days ago in approximately the same area. He does have previous Leos and batteries on his record, including harassing victim or witness. That was from 2014. We would just request no. That's all, Your Honor.
So, go ahead, Mr. Romero. $100, $25, $25. I'm sorry, $100, $2,500, $25, and $3,500.
Judge, we're going to be asking you to consider setting a bond on count 2 of $1,000, and we're going to be asking you to consider reducing the bond on count 4 from $3,500 to $1,000. Mr. Merico is 51 years old. At this time, unfortunately, he's not working. He's homeless. And Judge, I believe he's going to be trying to contact his girlfriend, who's also in kind of a financial similar situation where she doesn't have any sort of vast financial resources. He believes she may have $300, so that's what he's counting on. So he would be asking you to consider setting this at what I stated. He believed that's the premium that if she went through a bondsman she can afford, and that is the reason we made our request. We'd also be asking you to sign a photo order so we could photograph Mr. Merico's injuries, Judge.
Okay, the court will grant your photo order. Where's he gonna live?
He's homeless, Judge.
I know he's homeless, but can he live anywhere? Can he live at his girlfriend's?
Powerline Road in Oakland. He says there's a shelter that he sometimes stays at, so that's where he'll be staying, Judge.
Your Honor, State requested for count 2, $5,000 bond. What did you?
You said $2,500.
I request $5,000, Your Honor. I meant to request $5,000 bond.
Okay. Okay, go ahead. Anything else? Okay, State wants $5,000 on count 2, Mr. Romero, just to let you know. I didn't know if you heard that. Here's my concern, Mr. Romero. This isn't just a one-time incident. This keeps happening. I mean, I don't know if you've had the opportunity to read this affidavit, but okay, this is what the court's gonna do. Count 1, $100. Count 2 is $2,500. Count 3 is $25. And count 4 is $3,500. Thank you. Kevin Jamal Barnett.
Judge, could we recall that briefly?
Sure. T-Ven Jamal Marion, M-A-R-I-O-N.
Mr. Marion is here present, Judge. At Maine, he is approaching, Judge.
Okay, good, sir. How are you?
All right.
Okay, you have disobeyed or avoid a traffic device. No bond attached to that. You have burglary of an unoccupied conveyance unarmed, $1,000 bond, and you do have a probation violation or community control. You have a no bond hold. I don't see any date he's going before his division judge. Can anybody tell me?
Judge, that's an out-of-state hold, and that's the concern I have. My understanding is, Judge, that the officer approached Mr. Marion based on a traffic infraction. On that traffic infraction, he realized that there was, I believe, a not in custody habeas out from 2014, hence count 2, which is a $1,000 bond. And speaking of Mr. Marion, we do realize that count 3 is a no bond hold. That's out of Oklahoma. It's an out-of-state hold. He advised me he was placed on probation December 2016. So So obviously that would be after the date that this alleged incident happened. So I don't think there's probable cause for that officer to have basically hold him on a 948 hold on count number 3, Judge.
Yes, but just speak loud so Mr. Romero can hear you. How long does that take? Approximately. Okay, they'll figure it out by the end of the day, Mr. Romero. Would you like to reset this for tomorrow? We can find out, or?
Yes, Judge, we can reset it for tomorrow.
Okay, why don't we just reset for tomorrow?
Hold on. Judge, he did advise me he has a local probation officer here in Broward County that he reports to, and he has all the information. So I don't know if it would help or expedite things if Mr. Marion could right now give somebody a probation officer's name and phone number so they can verify all this information. So we have all the
Can they
information.
do it if we reset it for the PM and see if you can
Yes.
find something out?
Yes, because Broward.
All right, so why don't we do this? We're just gonna reset this for the PM today, and if not, then we'll set it for the AM, okay?
That's a good idea, Judge.
All right, thank you. See you soon, sir.
We can recall Mr. Barnett if you wish, Judge.
Sure. Is that what you'd like to do?
He's in North Broward. Yes, please.
Okay. Kevin Jamal Barnett. Hello, sir. How are you?
I'm okay.
Okay, you have burglary, unoccupied conveyance, unarmed. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. I can tell you, sir, I'm going to order no victim contact, direct or indirect, with the alleged victim with the initials TLC. That means no contact, sir, in person, calling, texting, anything through social media. And also that includes, sir, nothing through third party, no contact or communication through third parties. You understand?
Yes.
Okay, the court does find probable cause. State, let's talk about bond on count 1.
State would be requesting a $2,500 bond, count 1.
Okay, can he afford a $2,500 bond?
No, Your Honor. I was going to be asking the court for pretrial release. The alleged victim in the case is the mother of Mr. Barnett's child, which is, I think, kind of how this whole thing got started. The address on his booking sheet, the 3850 address, is his mother's address where he would be living. He would be returning to court. And I would ask the court to consider pretrial release for Mr. Barnett at this time.
He does have a history of violating court orders, Your Honor.
Your Honor, the concern is that you already ordered no victim contact. The victim in this case, he has had in 2017 and 2016 pled out violation of no contact orders involving the same alleged victim. So obviously the state's concern is he's disregarded court orders to stay away from this person in the past. We're concerned he'll do it again.
Does he have children with them?
That's my understanding, Judge. They have a somewhat tumultuous relationship.
But even if he does.
How about third-party contact if they want to, for child exchanges?
No, that's fine. That's a whole separate issue. I'm just saying the reason we're asking for a $2,500 bond is he's shown in the past that he will not follow no contact orders at this moment.
And that's a bond he's not going to be able to post, Judge. And he, when confronted by the police, he admitted his responsibility in the case.
How old are his kids?
How old are your children, Kevin?
I have a 2-year-old daughter with her.
Okay, I am going to allow third-party contact for child exchanges. That means you have someone else can call, okay? Pick up the child or whatever it is, but you can't do that, all right?
Okay.
All right, and when I say no victim contact, I mean no victim contact, except for these third-party exchanges.
Can I explain something?
No, I don't want you talking about the facts of your case. Everything's being recorded,
It wasn't going to be
sir.
about the facts of the case. I was just going to say the reason why me and her have gotten back together.
Kevin, I would not say anything else at this point.
Okay.
Wait for the judge to make her ruling.
Okay.
Okay, this is what the court's gonna do. The court's gonna put him on standard pretrial release. However, I want him reporting 2 times a month.
That's fine, Judge. I'm sure
And I
Mr.
want him
Barnett can do that.
calling in twice a week. And then obviously, pretrial, he doesn't have to call in twice a week when he's reporting twice a week. Okay?
For the record, the state would object.
Okay, I understand, sir. That's fine. Thank you.
All right,
thank you,
make sure
sir.
you do what you're supposed to do, Mr. Barnett.
Sheldon Alexander Adderley.
Mr. Adderley is here present, Judge at Maine. He declined the services of public defender.
Okay, hello, Mr. Adderley. How are you today, sir?
How you doing?
Fine, thanks. Hold on, let me just tell you something. Count 1 is possession of cocaine, $1,000 bond. Count 2 is drug paraphernalia, $100 bond. Resisting an officer without violence, $100 bond. Count 4, tampering with or fabricate physical evidence, $1,000 bond. Count 5, loitering or prowling, $25 bond. And count 6 is a probation violation, which you are going, hold on, you are going before your division judge. Judge Ernest Cholera has signed a no bond hold for you, sir. You're gonna go before him on March 27th at 8:30 a.m. Any objection to probable cause?
Ma'am, you should really drop all of the charges because the only thing about that, I had just got out of the hospital and walked around the corner, and that shit was on the ground. It was on the ground. That stuff was on the ground, man. For real. I'm sorry about that, but it was on the ground, dog, and he charged me with that. I'm sorry about it, but that's how I
Okay,
felt.
sir, this is the problem. You have the right to remain silent. Anything you say can and will be used against you when you're talking about the facts of the case. And not only that, sir, you declined the services. Did he decline the services of the public defender?
Yes, I believe that he did, Your Honor.
So, the court found probable cause.
Hey, but I got my own lawyer. Could you just send Guy Sullivan there? Because, you know what I'm saying? I ain't trying to incriminate myself, but...
What's his name?
Guy Sullivan.
Seligman. Can someone call it? Hold on. Can someone call Mr. Seligman? Does he know you're in jail?
Yeah, I've been trying to get in contact with him. We've been talking. I can give you the number.
Sure.
It's area code 954-676-7600. Tell him Sheldon Adderley needed.
We're sorry, you have reached a number that has been disconnected or is no longer in service.
No, that ain't the right number.
You have reached this
It's not the right number, Your Honor. It's 954.
Hold on.
760.
Okay.
7600.
It's 760-7600? Oh, that's a good number.
Good morning, law officer.
Yes, hi, Mr. Guy Seligman. This is Judge Malika calling from First Appearance Magistrate Court.
Okay, I'm sorry, Judge, what's your name?
Malika, Mollica, first name Kim.
Okay, and which client is this on?
This is Sheldon Alexander Adderley.
Okay, hold on one moment.
Good morning, Your Honor. This is Attorney
Hi, Attorney Guy Seligman. You're on speakerphone. We're in first appearance court. This is Judge Kim Malika. How are you?
How are you, Judge? Good morning to you.
Good morning to you as well.
Are we on the matter of Sheldon Adderley?
Yes, we are.
I believe he has two matters pending before the court. One is a violation of probation, which is outside of Your Honor's division, and the other is the new substantive matter, which includes the possession charge.
Yes, the VOP, he has a no bond hold. So that he's going before, who is it, Judge Kalra on 3/29, which is next Thursday, a week from tomorrow.
Excellent. I'll put that in our calendar.
Okay.
I'd also ask the court to consider setting reasonable bail for the remaining charges, at least card rates, since they are not crimes of violence.
Okay, bonds are currently set at, let's see, 1,000 for the possession of cocaine, 100 for the drug paraphernalia, resisting without 100, tampering with or fabricate 1,000, and loitering or prowling 25.
Very good. Anything further you need from me, Your Honor?
Yes, the court is going to order no return to,
I believe it was a vacant lot, Your Honor.
they have a no trespass, it says in front of an establishment. I'm just going to tell them no return to 321 Northwest 6th Street.
Understood.
You understand that, sir?
Did he respond to the court?
He's trying, he turned off the microphone because there's a lot of background noise.
Thank you.
All right, sir, so your bond is going to be kept at $2,225, and you have a no bond hold. Your attorney will address that with your division judge, okay? You're going to come and see him at the jail, Mr. Seligman?
I'm going to invite him to call me collect after hours like he usually does. I don't make a lot of jail visits because of health issues right now.
All right, well, he was apparently dialing the wrong number. It's 760-7600. By the way, you have a really good number.
Thank you, Your Honor. He reached me 3 times last night, so I'm confident in his ability to remember it.
Well, he gave us the wrong number initially today, so.
He was probably nervous in front of Your Honor. I can understand that.
Okay, all right, well, thank you.
Thank you, Your Honor. Good day.
Good day. All right, thank you, sir. You're done, okay? Call your attorney. Jordan Tyler Pinkney.
Mr. Pinkney is approaching, Judge. He's here at Maine.
Okay, Mr. Pinkney, you have count 1, aggravated battery with a deadly weapon. We need to talk about bond. Grand theft auto, $1,000 bond. Operating without a valid DL, $25 bond. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. The court's going to order no victim contact, direct or indirect, with the 2 alleged victims in this case, with the initials EMRM and ET. Direct or indirect, sir, means in person through third parties. I want you to listen, sir. It's really important. Direct or indirect contact means contact in person through third parties, calling, texting, through social media, or any other means. You understand?
Yes.
Okay, let's talk about bond on count 1, State.
Your Honor, looking at this criminal history where there are a number of thefts and there is a level of violence in this, they will be requesting a $50,000 bond.
50,000?
Yes, Your Honor.
All right, tell me about his priors, please.
So 17, he has uttering forged instrument. 2016 petty, and a grand theft. He has a 2016 petty theft, felony petty theft. He has another felony petty theft in 2016. 2015 possession of cocaine, also felony petty theft.
What do you have of crimes of violence?
Well, no. Well, this one, Your Honor, and it reads as a carjacking, being that he did strike the victim while he was trying to take her vehicle. So due to the nature of this offense that he's charged with, Your Honor, that's the reason why the state's requesting the bond amount.
I'm just reading something, Mr. Romero, and then I'll give you an opportunity. Okay, go ahead, Mr. Romero.
Judge, since being Mr. Payne, he's 28 years old, been living here about 10 years in South Florida. He works off and on doing construction. He lives in Pompano with his mother. His mother basically has 3 jobs. From what he advised me, she doesn't have any sort of financial resources to post his monetary bond. And speaking with Mr. Pinckney, he has no financial resources to post his own bond. He has no sort of money in the bank, no sort of homes or anything like that that he owns. Judge, for all practical purposes, he is financially indigent. I'd ask you to take that into consideration in determining a reasonable bond on Mr. Pinckney, and I'll also ask you to sign a photo order so that we could photograph Mr. Pinckney's injuries that he sustained, Judge.
Also, Your Honor, there is priors out of Tennessee. There's a 2010 assault on law enforcement officer and a 2008 aggravated burglary.
Okay, court's gonna set the bond on count 1 at $10,000, 1,000 on count 2, 25 on count 3, GPS level 2. Thank you. Jamal Arthur Long, please.
Mr. Long is here, present, Judge, at Maine.
Okay, good morning, Mr. Long. How are you?
How you doing, Judge?
Good. You have sell PVP, $1,000 bond, sell cocaine, $2,500 bond. Court does find probable cause. Anybody want to be heard with regard to the $3,500 bond?
Your Honor, Jackson from pretrial, Mr. Long. These new charges is violating the condition of pretrial on case number 18-1297, CF10A, possession of cocaine.
When was he placed on pretrial?
Check, Your Honor, one moment. Double checking, Your Honor. It looked like he never reported. He was placed on pretrial.
He never reported?
Hold on.
Judge.
I take it back. I take it back.
I never.
Hold on,
Judge,
he's taking it back. Hold on.
He left a voicemail. He was placed on pretrial February 2nd of this year. And he called in. That's a voicemail. He did call in. So February 2nd is when he placed on pretrial, Your Honor. So he did call in. They interviewed him at the jail on February 5th. And then he called in February 9th. Said he had a status hearing with Judge Fine. That was February 12th. That was the last reporting.
Okay, you want to be heard with regard to bond, Mr. Romero?
Judge, yes, Mr. Long is asking me to ask the court if you would consider releasing him on standard pretrial on these offenses. Also, for clarification, Judge, Mr. Long is inquiring on count 1. I believe it's a 3rd-degree felony, and on count 2 is a 2nd-degree felony. I just wanted to go ahead and confirm that.
State?
Yes, it is, Your Honor.
Yes.
And these are new law offenses, is that correct?
Yes.
Okay. Judge, at this time he's not working, he's looking for work. He is currently homeless. He does have a mailing address, and that is of his grandmother who resides in Fort Lauderdale. Judge, at this time, any sort of monetary release conditions or anything like that, he's positive that he cannot afford and nobody would be able to post his monetary bond. I do understand that he's currently out on pretrial release on another case, Judge. But he's asking me at this time for you not to take any action on that case and release him on pretrial release on this case, Judge.
Is the address 3055 Northwest 5th Street, Fort Lauderdale, where he gets his...
Yes, ma'am.
All right, this is what the court's going to do. The court is going to defer for the division judge on the case that he does have, the 18-1297. Court is gonna put him on standard pretrial release, however, court is gonna leave the 2 bonds at $1,000 each count. The court is gonna make him report 2 times a month in person. And that's the same as the other one, when he reports, he only has to call once. Okay?
I can't hear her. Sorry, Your Honor.
1,000.
What did you say about reporting, Your Honor? I missed it.
He has to report 2 times a month,
Okay. Thank you.
okay? He has to call in twice a week on those other weeks.
Okay, thank you.
Okay? All right, Terry Dugazon. Good morning, Mr. Dugazon. You have 1 count of possession of cannabis, 20 grams or less, $100 bond, and 2, 3, and 4 are not for magistrate. Court does find probable cause. Anybody want to be heard with regard to the $100 bond? He also was a no-show.
Not at this time, Judge.
Okay. $100 bond it is. Thank you. Tony Lamont Johnson, and then Willie Borden, please.
Mr. Johnson is here present, Judge, I may?
Good morning, Mr. Johnson. You have count
Good
1,
morning.
possession of cocaine, $1,000 bond. Then you have possession of drug paraphernalia. There's no bond attached to that. Court does find probable cause.
Your Honor, this appears to be a residue case which will most likely be filed strictly as a possession of drug paraphernalia charge. I'd ask the court to take that into consideration when setting bond for Mr. Johnson.
Okay, anybody want to be heard with regard to the $1,000 bond?
Yes, Judge, we do. We'd be asking you at this time to consider releasing Mr. Johnson, ROR. He's 48 years old at this time. He's looking for employment. He's been living in our community for over 30 years. Unfortunately, at this time, he is homeless, and unfortunately, from what he told me, he also has no mailing address. But I'd ask you to consider what my colleague did state. This is a residue case. We're looking most probably just at a misdemeanor drug paraphernalia, and therefore, at this time, Judge, I'd ask you to consider releasing him ROR on Mr. Johnson's behalf.
Does standard pretrial speak to people that do not have an address about when their next court date is when they come in?
Yes, Your Honor, we do.
Okay. All right. State, any objection to standard pretrial? I would have them report twice a month, call in twice a week.
Who's this again, Your Honor? Forgive me.
That's okay, Tony Lamont Johnson.
Okay.
Any objection, State?
State would object. He does have previous violent felonies in his past, and also previous failures to appear.
Okay. All right, standard pretrial, report 2 times a month, call in twice a week.
Yes, Judge. Wait, I
And
gotta
the
give you a minute.
and the call in twice a week, Mr. Romero, are the weeks that he does not report. Tell him what happens if he doesn't report when he gets out of jail,
There'll be a no
and
bond
if he
warrant.
doesn't report in person or gets a new charge.
Okay, and sir, as soon as you get released, you'll probably get released today.
Mm-hmm.
Well, you will.
Okay.
And so they'll be open, you just walk across the street, you report to pretrial, okay?
It's right here in Fort Lauderdale?
Correct, it's across the street. See how the jail is, and there's an arrow pointing across
Oh,
the street?
okay.
You go there, simple. So make sure you go there.
How many times I report?
I believe it's twice a month, Judge, and call in twice a week.
Call in twice a week, report twice a month in person. But when you-
Okay.
Okay,
Oh, thank you. Thank you.
thank you. Willie Borden, please. Willie Borden?
Mr. Borden, come on up, please. He's approaching, Judge.
Okay, Mr. Borden, you have 1 count of possession of cocaine, sir. $1,000 bond, counts 2 and 3 have no bonds attached to them, which is possession of drug paraphernalia and trespassing. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. There's no return, sir, to the Saxon Wall Market. Do you understand, sir?
Yes.
Okay, they don't want you going back there clearly. So what are we doing on count 1? Want to be heard? Defense?
Judge, we're going to be asking for an ROR on Mr. Borden's behalf. He's almost 70 years old. Unfortunately, he's homeless, but he does have a mailing address. It's of a person that lives in Pompano. And at this time, there's no financial way he can post bond. obviously, Judge, he's not a threat to the community. He's gonna come to court, Judge, so we'd be asking you to consider an ROR on his behalf.
Possession of cocaine, possession of drug paraphernalia, for failing to appear in court.
Judge, we can't hear what's being spoken. It's like a mumbled sound.
Go ahead, Mr. Winter, state it again. He has a note, I'll tell you what he said. I have a capias case number 17-12573, CF10A. I cannot sign by the clerk. He has 2 no-bond holds and no show to court for possession of cocaine, possession of drug paraphernalia, or misdemeanor. He didn't show up for court. January 25th, 2018. Did he bond out on these initially? Had a change of charge on January 4th. Go on. Wonder why it was returned. All right, so what is the state asking me to do?
Your Honor, I'm asking the court to order Mr. Borden to be held no bond on 17-12573 CF10A
Well,
pursuant
why
to...
isn't it's Judge Tim Bailey, by the way. Why isn't the jail doing it?
Your Honor, they can only act based on when BSO warrants serves in the cases. But, Your Honor, I'm proceeding that it has now been brought to your attention that the valid capias has been issued by Judge Bailey.
Okay, so what would you like me to do?
Again, I'm asking you to order him to be held no bond pursuant to the capias that was issued by Judge Tim Bailey on January 25th of this year.
Okay, I am going to have to do that because he was a no-show, and this was before Tim Bailey on January 25th. So you can give that copy. I don't know if you need it. Sheila? No? No, there's a no bond hold by Judge Bailey on a capias that was not served on him.
So they're gonna go ahead and take you in on that 2017. Who's your attorney on that case, or did you apply for public defender or anything?
Yes, he did.
It's Kristen Taylor.
It actually got returned from your office, but the clerk's office didn't get it. The clerk's notice did not get returned, interestingly.
Judge,
so what do you want to do
Your
with
Honor,
count 1?
If Your Honor is going to go ahead and basically remand Mr. Borden in custody due to the 17-12573 CF10A outstanding no bond warrant case, in that case, I would be retracting my, I guess, suggestion as far as an ROR on count 1. I'd ask you at this time to set a $100 bond on count 1.
Okay, $100 bond, no return to Saxon Wall Market. Thank you. Good luck to you, sir. Juan Alfredo Bailey. Tell him he's got to find out when his court date is again.
I don't see one right now, Judge.
Okay. All right, Juan Alfredo Bailey.
Mr. Bailey is here present, Judge, at Maine.
Okay, you have grand theft of a firearm, sir. Bond set at $1,000. The court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim in this case with the initials JM. Direct or indirect contact, sir, means in person, through third parties, calling, texting, through social media. You understand, sir?
Yes, ma'am.
Okay, thank you. Can you put that about my stamps, too? Okay. Want to be heard with regard to the $1,000 bond?
I'd like to be heard as to probable cause.
Sure. You're gonna stop me.
No, that's okay, Judge. On post Miranda, apparently Mr. Bailey stated that he found the gun near the Sawgrass Mills Mall and kept it. It has nothing to do with whether or not he stole the gun. And the charge is grand theft of a firearm, not possession of a stolen firearm.
Okay, state.
One second.
Hello, which case are you here on? Okay.
It does allege that the firearm was reported stolen. The PC doesn't indicate whether there's anything indicative of the gun itself to put him on notice that it could potentially be stolen or something.
Okay, so state. Anything further?
State would just argue that he knew or should have known that it was stolen. He didn't purchase it, and it's just only his statement saying that he found the gun. We have no way to confirm that.
Okay, the court is going to find probable cause. Respectfully, Mr. Reedy. So.
Judge, Mr. Bailey informed me this is his first contact with the criminal justice system. Certainly, I'd ask you to take into account what my colleague stated. I believe a case filer is going to find that information useful, and we might not even be here in 30 days, or Mr. Bailey won't even have to worry about this case in 30 days. But in the meantime, Judge, I'd ask you to consider an RWAR if the state can't confirm this is his first offense ever. In the alternative, then, I would just ask you to leave the standard bond in place.
State, anything further?
Keep the bond keep the bond as is, but he does have a 2018 possession of cannabis case in front of Judge Levine in West.
In that case, Judge, I'd ask you just to leave the standard bond in place.
All right, so the court will leave a $1,000 bond in place, Mr. Romero, and grant your request.
Thank you, Judge. I'll call your mom right after court, okay, sir?
Jacqueline Jasmine, please.
Mr. Jasmine, come on up, please. He's here present.
Okay, Mr. Jasmine, good afternoon, sir. You have a battery on an officer, firefighter, EMT, and resisting an officer with violence. We need to talk about bond. Count 3 is trespassing unoccupied structure, $25 bond. Any objection to probable cause?
No, Your Honor, but it's very close to a resisting arrest without violence. It appears that the with violence is the slapping of the officer's wrist, Once Mr. Jasmine was taken to the ground, the report indicates he became compliant and the officers were able to handcuff him. Other than that, it seems a lot of tensing and language we often see associated with resisting arrest without violence.
Is David Todd Tripoli, is he from, he's not law enforcement, is he? Let me see, yes he is. All right. All right, so sir, the one thing I'm gonna do is, on the onset, I'm gonna order you no return to the Gold Key community. Do you understand, sir?
Yes.
You don't live there, do you, sir? No?
Do you live there? You do? Judge, he does live there, is what he's informing me.
Okay, what's his address?
What's your address?
Where I live?
Yep.
I live 61. Yeah, 61.
6861.
Northwest.
Northwest 25th Court? 25th Court. Is that a house or apartment?
House.
It's a house, okay. And what city is that in?
Sunrise. So I don't get it.
Sunrise?
Yeah, I don't live in.
And what's the zip code?
333.
What?
33313.
Judge, he advised me his address is 6861 Northwest 25th Court. It's a house, not an apartment, in Sunrise, Florida, 33313.
Is that where he lives now? Is that his mailing address? Because I have him at large.
That's where he's going to be living, Judge.
Okay, State, what do you recommend him for bond on 1 and 2, based on the facts in this probable cause affidavit?
State will be requesting a $1,000 bond on count 1 and $100 on count 2.
There is a victim contact notification sheet, by the way, for this officer. So. Okay, so Mr. Romero, they're asking for $1,100.
$1,100?
Mm-hmm.
1,000 on 1 and 100 on 2, Judge?
Yeah, I'm sorry, and $25 on 3.
$25 and 1,000.
It's 1,100. It's about basically $1,100.
Let me inquire and see if he can give me any number for him to post. Hold on one moment, Judge.
What was the, oh. Tell me later? Okay. Person after this is going to be Adrian Roger Clayton, and then Keith Bouvier Dennis.
Judge, he gave me a phone number of another cousin, Justin, and I'm going to be calling him to have Justin post the monetary bond, which the state has suggested, Judge.
All right, do you want to talk to him, or do you want to reset it for this afternoon, just in case?
No, I'm going to go ahead and call him.
All right, so $1,000 and 100,
Yes, Judge.
and then tell you what I'll ROR on 3, okay?
Yes, Judge. And can you just sign a photo order as well, Judge?
Sure.
Thank you, Judge.
Adrian Roger Clayton, please.
Mr. Clayton's here at Main Judge.
Okay, Mr. Clayton, you have a charge, count one, driving while license is suspended. Habitual, that's a felony, $750 bond. And then you have driving while license is suspended. Is it a felony for the count one? Okay. And then count two is driving while license is suspended, third or subsequent offense, $750 bond. The court does find probable cause, $1,500 bond total.
Judge, Mr. Clayton's going to be requesting if you would release him on standard pretrial release. From what he advised me, he works at a car wash. He makes about $65 a day. He lives in Fort Lauderdale with his roommate. He just moved in recently, and his roommate's going to be charging him $350. He did advise me as priors, but it's like from 2014. So if that's correct, 4 years old, I'd ask you to consider releasing him on pretrial release.
Your Honor, he was released December 9th, 2016 for carrying concealed firearm, possession of controlled substance, grand theft, possession of marijuana with intent, fleeing and eluding, and a burglary dwelling, an occupied dwelling, and he was sentenced to 2 years, 3 months, and 23 days.
In December?
That's when he was released. He was,
So he was released in December?
yes, of 2016, Your Honor.
Okay. Mr. Romero, any response?
Yes, Judge. Judge, since he's been out, he told me he hasn't gotten in trouble, so. And the one time I don't. So, Judge, for pretrial release, he has a valid address.
What's 2920 Northwest 56th Ave, apartment B402?
What is that, sir?
That's an old address.
That's an old address, Judge. His new address, I believe, is in Fort Lauderdale with his roommate that he just moved in recently.
Does he have the address?
What's the address?
1340 Northwest 4th Avenue.
1340 Northwest.
I literally moved 2 days ago.
Okay, 1340 Northwest.
4th Avenue.
Is this a house or apartment?
It's a house.
House, and it's in Fort Lauderdale. What's the zip?
33311.
Judge, it's 1340 Northwest 4th Avenue. It's a house, 33311.
Okay, I'm going to have the clerk update his address. But, sir, if you move and that you don't get your mail there any further, you are going to have to notify the clerk of court in writing immediately with all your case numbers. So you make sure that you get notice. Additionally, you can also check on the computer. All right. Anybody want to be heard further?
No, Judge.
Okay, this is what the court's going to do. The court will put him on standard pretrial release. What does he do for a living, you said? Did you tell me? I don't remember. I'm
He's
sorry.
at a car wash. He's been there now for about 4 months, Judge. So he is working, making about $65 a day.
Okay, I want him calling in 3 times a week. He only has to report in person the first time, okay?
Thank you, Judge.
All right, thank you, sir. Make sure you call in, sir. No further law violations. Keith Buvia Dennis.
Mr. Dennis is here present, Judge.
Okay, Mr. Dennis, good afternoon, sir. You have possession of cocaine, $1,000 bond. Counts 2, 3, and 4, we don't have a bond attached to it, so that's basically an ROR. It's possession of cannabis under 20 grams, resisting an officer without violence, and operating without a valid DL. You do have operating a motorcycle without a license, and it says no bond. Is that correct?
I believe that's it.
That should say NC, I believe, correct? All right, and then we have 3 traffic infractions: motorcycle, no tag light, eyewear, or headgear. So total bond is $1,000. Court does find probable cause. Anybody want to be heard? Oh, and there's a count 9, which is also not for magistrate, no helmet. or insurance? Go ahead, Mr.
Judge,
Romero.
he gave me the phone number of his mother, and I'm going to be contacting his mother so she can post his bond.
All right,
Your Honor,
go ahead.
the state's seeking a bond increase from count one from $1,000 to $2,500. He has a 2012 possession of. Okay, he does have a case that he just bonded out of March 13th, and that was a possession with intent to sell cocaine. Your Honor said within 1,000 feet of a specified area. Your Honor set a $5,000 bond for that, and he also had a possession of 20 grams. Your Honor set a $100 bond for that, and he was just released Tuesday. Now, he has a 2012 possession of cocaine with intent, resisting without, and corrupt by threat. Oh, that was a client. Okay. He has a VOP, another 2012 possession of cocaine with intent. That was also a VOP, which was revoked. He was sentenced to 270 days. Your Honor.
Okay, Mr. Romero.
We still have our original position, Judge.
Where does he live?
Where do you live, sir?
I live 204 Northwest 28th Drive.
Apartment A.
Yes.
Hello. All right. All right, this is what the court's gonna do. The court's gonna set $100 bond, GPS open scheduled. Thank you.
Judge, in the alternative, we
Mr.
appreciate you
Romero.
going it.
Hold on. He's not done. Let him finish. Go ahead.
It's not just a matter of knowing where he is, but why he is where he is, would be concrete trial where he is.
All right, go ahead, Mr. Romero.
Judge, I'd ask you, and I know Your Honor reduced it quite a bit from $1,000 to $100 with level 2 GPS. Would Your Honor be inclined to leave the standard bond in place of $1,000 and just delete the level 2 GPS?
No. Sorry. Thank you.
Yes, Judge.
Jermaine Allen. Jermaine Allen. Who do you have left there? Anybody, Mr. Romero?
I believe Jermaine Allen, he may be. Hey, Judge, I've been advised he bonded.
Okay, and then I have two more here, so just hold on.
Yes, Judge.
Anthony Sheenfont. I think it looks
Medical
like
loan,
CH.
Judge.
Okay.
I believe he's a medical reset judge.
Okay, and then Jerome Lender Paisley.
Medical loan, Judge.